Hearing in the appeal, Commissioner of Police Metropolis and DSD and another.
Before we start, I should just announce that the court is ordering that nobody should publish or reveal the names or addresses of the respondents involved in these proceedings, or publish or reveal any information which would be likely to lead to the identification of them or any member of their families in connection with these proceedings. And if anyone's unclear as to the precise terms of the order, copies are available. Thank you.
Thank you, my Lord. My Lord, my Lady, I appear with Jeremy Johnson for the Appellant Commissioner. Philip Kaufman and Ruth Brander appear for the respondents. The appeal is supported by the Secretary of State for the Home Department, represented by James Eadie and David Pievsky. The respondents are supported by Liberty, represented by Karen Stain and Hannah Slarks, and they're also supported by Rape Crisis England and Wales, End Violence Against Women Coalition, Southall Black Sisters and NIA Project. They're represented by Karen Monaghan, Helen Law and Kirsten Cheval.
Thank you.
My Lords, my Lady, Mr. Eadie and I have been allocated 3 hours between us on our side, and my friend has very generously told me that he has no objection to me taking a larger share of the 3 hours than has been advertised, but we will keep, of course, to our allocation between us. The court will have seen that the issue in this appeal is whether Article 3 of the Convention, the European Convention on Human Rights, imposes a duty on the police to conduct an investigation into serious criminal offences committed by a private person, and to do so in an effective manner. And if there is such a duty, what does it connote? What are the limits of it? Our case, what we will be inviting the court to do is to allow the appeal so that a dialogue can take place between this court and the Strasbourg court for these reasons. First, because we say the imposition of an investigative duty raises policy concerns, as this court and the appellate committee before it have repeatedly recognised. The law of this country, that's subject to the Convention, subject to the Human Rights Act, does not recognise a general investigative duty, in part because of a concern that any such duty will reduce the efficacy of police investigations of crime. And if Article 3 does impose an investigative duty, those concerns will be undermined. Second point we will be making is that the Strasbourg court has not spoken consistently on this issue. Some cases, including Grand Chamber cases, refer to an investigative duty arising only where the serious crime is alleged to be committed by state agents, or where the victim is a person for whom the state has special responsibilities, in particular children who've suffered sexual abuse. We recognise that there are many cases, and
Osm-type duties, is that?
Yes, there's also a protective duty, yes.
Yes.
There's
Special situations.
Special situations, either committed by state agents, or there's a child who suffered sexual abuse, or the state knows or has reasonable cause to know that there is a real risk of an imminent attack on a specific person. We recognise there are many cases in which sections of the court have gone further, and they have recognised there is a general investigative duty which requires courts to look at the details of the investigation to see if it was carried out effectively, although the Strasbourg court has also emphasised that this duty, this investigative duty, is not concerned with errors or isolated omissions in the investigation. And the court will want to look at those cases. Some of them concern inadequacies in the laws of the contracting state. Some of them, on analysis, concern ill treatment by state agents, and some of them, as my Lord Mance indicates, are Osman-type cases. Some of them, as I say, are cases where the state has a special responsibility. we say that the case law of the Strasbourg Court, particularly at Grand Chamber level, is very far from being clear and consistent. The third point we will seek to make is that the Strasbourg cases have not addressed the public policy concerns which have led to the reluctance of our court to recognise an investigative duty. The Strasbourg cases have focused on effectiveness, but without being asked to address whether it is within the discretionary area of judgment or the margin of appreciation for our law to decide that an investigative duty would make the investigation of crime less effective, especially where the state provides other means of protecting the interests of the victim, means such as compensation under the criminal injuries regime, actions directly against the wrongdoer, disciplinary actions against the police, matters of that sort. The fourth point we will seek to make is this: even if a general investigative duty does arise in respect of serious crime, the sections of the court have recognised that Article 3 does not allow the court to grant a remedy for errors or omissions. And the question for this court under this heading is where does one draw the dividing line? And we say that there are authorities which indicate that the dividing line is at a high level, that provided there's an investigation in good faith, and there is not a failure so serious that it negates the very idea of any investigation at all, the Article 3 duty is satisfied, particularly where there has been, on the facts of the individual case, a conviction of the wrongdoer, and or compensation has been obtained from the primary wrongdoer. So we will invite the court, after taking into account the Strasbourg case law, which of course is the duty of this court under Section 2 of the Human Rights Act, we will invite this court to allow the appeal so that these important issues can be addressed by Strasbourg, hopefully by the Grand Chamber. If the appeal were to be allowed, it would enable the respondent, should they wish, to take the case to Strasbourg and for the United Kingdom to seek to persuade the European Court that an investigative duty does not apply.
Is it right for us to say to ourselves, well, we're not sure what the answer is, or we think the law is in a certain amount of uncertainty, therefore we're going to find in favour of the government so the matter can go to Strasbourg? Or is it more that we have to make up our minds what the right answer is, irrespective of what might happen thereafter?
Well, the court only needs to take account of the Strasbourg case law. The court's not bound by it, but the court does need to form a view. I'm not suggesting that the court adopts a neutral view on this matter, but I am submitting that having regard to the content of English case law absent the Human Rights Act, the court should allow the appeal unless it is satisfied that there is a very strong correct case under Article 3 for the respondents. The difficulty in practical terms is that if the court were to dismiss the appeal, there is no way in which this matter can come before the Strasbourg court. That is the practical difficulty.
Well, that's the practical difficulty, but the question is, what influence should that have on us? There have been some judicial suggestions in the past that the court should be influenced by the circumstance that it's not open to the government to take a case to Strasbourg. Let me be frank and say that I rather doubt that that is a correct approach, but I'm open to persuasion.
Well, I need to persuade your Lordship, obviously, but I do submit that in the light of the consistent line of authorities under English law, I appreciate, of course, the test under Article 3 is different. There are real policy concerns and difficulties about recognising an investigative duty. And I say, when one looks at the Strasbourg case law, the proper analysis, certainly at Grand Chamber level, is that the investigative duty does not extend as far...
I quite appreciate that, Lord Penning. The question, I didn't put it properly. Lord Brown in particular suggested in one case, I think Alskeny, that because there was no opportunity for the government to take a case to Strasbourg, that should be a factor which should influence the court's decision against the applicant in that particular case, or the appellant in that particular case. I question whether that's a proper approach. I mean, the contrary view is that the court has a constitutional obligation to reach a decision, and it shouldn't be influenced by extraneous factors such as, well, if the appellant fails here, she'll always have another chance in Strasbourg.
Yes. I say this is a most unusual circumstance because the issue that your Lordship's putting to me doesn't arise in a vacuum. It arises in a context where this court and the appellate committee before it has addressed the contention that there is an investigative duty on many, many occasions and has reached a clear view as to the disadvantages of imposing or allowing such a duty. And I say in that context, the court should be very slow, unless it is convinced that the Strasbourg case law clearly so requires, to adopt a different approach.
What about, I mean, I see the way you've been discussing it with Lord Kerr, but are you actually submitting that the domestic considerations are so strong that we should refuse to follow a Strasbourg line, even if we thought that there was one?
Well, my position is there is no Strasbourg line at Grand Chamber level.
I've understood that, but supposing we conclude that other things
if your Lordships were satisfied that there is a clear and consistent line of authority at Grand Chamber level, then I think I would have to accept that it would be a very, very rare case. I wouldn't say never, but it would be a most unusual case where this court would decline to follow the Strasbourg jurisprudence. But I submit that is certainly not the circumstances of this case. There are a number of chamber decisions that at Grand Chamber level, I say, if anything, the position is the other way. But I'll take the court to that, if I may. The court will have seen, I'm not going to go through it in detail, but the court will have seen from the statement of facts and issues that the proceedings arise out of the appalling crimes of sexual violence committed by the driver of a London black cab, John Warboys. He's serving an indefinite term of imprisonment for public protection. Each of these respondents was attacked by Warboys. His convictions included one for sexual assault in respect of NBV. He was not charged with an offence in relation to DSD, but only because, after the passage of time, she had understandably been unable to identify him. Mr. Justice Green awarded damages to each of the respondents because of the multiple failures in the investigations into the violence against the respondents. And those failures are set out in some detail in the statement of facts and issues at paragraphs 22 to 25 of the agreed statement. And the court will have seen they include both what are described as systemic failures, failures of training, failure to follow proper procedures, and failures in the actual carrying out of each of the investigations. That's all set out in detail. The Commissioner has accepted the judge's findings as to the investigatory failures. The Commissioner has apologised to the respondents. He has recognised they were badly let down by the Metropolitan Police Service. I repeat that apology. The Metropolitan Police has sought to improve its policies and practices in addressing allegations of sexual violence since 2007, after NBV's case was inadequately investigated. The court may also have seen that whatever the outcome of this appeal, the Commissioner is not going to seek to recoup the compensation ordered or the costs which he's been ordered to pay, and the Commissioner has agreed to pay the respondents' costs in this court. I said he in relation to the Commissioner. The new Commissioner is Cressida Dick, but she's not yet taken up her post. There is no date, as I understand it, for her to commence her duties. And the acting Commissioner is Mr. Craig Mackey. Before coming to Article 3, can I first say something about the general legal position in relation to investigations by the police, by reference to the Michael case, which the court has in Volume 1, tab number 3. And of the 7 justices on that case, President, Deputy President, Lord Mance, and Lord Kerr were all members of that court. It was, as so many of these cases are, an appalling case. The court will have seen that the victim had made an emergency call on her mobile phone to the police from her home, and she said that her partner had found her with someone else. He'd bitten her ear really hard. He'd gone off in the car. He'd said he was going to return to hit her. And then she reported that he'd said he was going to return to kill her. And the police did not act speedily, as of course they should have done. And before they had time, before they'd responded, some 15 minutes later, she called 999 again. She was heard to scream. And the man concerned, her former partner, had stabbed her to death, and he was subsequently convicted of murder. And the question in that case was whether or not, having regard to the proximity between the victim and the police, that the victim had phoned the police and had told them of the danger, whether or not there was an investigative duty under either under common law or under Article 2, and the court allowed the Article 2 claim to proceed. This was a strikeout claim, but the negligence claim failed with my lady, the Deputy President, and my Lord Kerr dissenting. And dissenting, I hope I accurately summarise it, on the specific basis that this was a case where there was at least a reasonable degree of proximity between the victim and the police. She had phoned the police, and the police had been told of the danger that she had faced. And what the courts...
And that it was fair, just and reasonable. And that it was
Yes.
fair, just and reasonable in the particular circumstances of
Yes,
that case.
yes, indeed. Lord Torson gave the judgment for the majority of the court, and he emphasised, first of all, at paragraphs 29 to 34, that there was a public law duty on the police. The police had a public law duty to investigate crime, and that duty, in extreme circumstances, would be susceptible of a judicial review application, but only, of course, in exceptional circumstances. He also referred to the investigative, to the powers of the police and the duties of the police to deal with independent oversight through a complaints system. Of course, the victim of crime can receive compensation from the Criminal Injuries Compensation Authority, and in this case, in the present cases, that is what has happened. If the court would go in the core volume, looking at the memory stick page number 4848, the court will see in the judgment of Mr. Justice Green on quantum, page 4848, paragraph 42, is the introduction. This is paragraph 43. The Commissioner submits there's no justification for making financial award, bearing in mind the fact that the respondents have both received payments from their civil High Court claims against war boys and from the Criminal Injuries Compensation Authority. Both of them brought civil proceedings against war boys and his motor insurer. The claims against war boys were settled. The total recovery totaled £207,000 odd. The claims against the insurer were dismissed. And in subparagraph 4, out of the total recovery from war boys, the claimants, as I understand it, each of them, received the net amount, well, it says received the net amount of £10,000 each by way of settlement, and under 5, they also obtained compensation from the authority. and the figures are there set out. DSD received 13,500, MBV 2,000. And I draw attention to that because some of the Strasbourg cases suggest that this is relevant to whether or not the Article 3 duty has been met by the state. So that's public law and private law actions against the wrongdoer. The courts have repeatedly held, however, that there's no private law duty of care and negligence owed by the police to individuals for a failure in the investigation of crime, particularly on the basis that it would not be fair, just and reasonable to impose such a duty for policy reasons. And the developments over the last 30 years are summarised in Michael. Lord Toulson referred at paragraph 36 to the Hill case, the claim brought by the mother of the last victim of the Yorkshire Ripper, Peter Sutcliffe. And Lord Toulson summarises the reasoning, very familiar reasoning of Lord Keith, at paragraphs 41 and 43. And I won't read all that out. I would, however, like to go to the next case, which is Brooks and Commissioner of Police, and that appears behind tab 1 of the same volume, Brooks and Commissioner. This is a 2005 judgment. And looking at the head note, it's page 11, tab 1 of the same volume.
Thank you.
Page 11 is the head note. The claimant...
And what's the electronic page?
11.
11.
Is it 11?
Yeah.
Yes, MS page number 11, memory stick 11. It's the first case.
Okay.
The claimant and his friend, L, who of course was Stephen Lawrence, who were black, were set upon by white youths in a racist attack. Stephen Lawrence was killed. The claimant was dealt with by the police in a way that was subsequently the subject of severe criticism in the report of an inquiry against the defendants, the Commissioner of Police and others, and he claimed damages for negligence. And at D, the judge struck out his action against the officers and the Commissioner. On appeal, the Court of Appeal allowed his appeal in relation to his claim in negligence against the Commissioner in respect of 3 duties of care that he alleged had been owed to him by the police, namely, to take reasonable steps to assess whether he was a victim of crime, and if so, then to accord him reasonably appropriate protection, support, assistance and treatment, to take reasonable steps to afford him the protection, assistance and support commonly afforded to a key eyewitness to a serious crime of violence, and to afford reasonable weight to the account that he'd given of events and to act on it accordingly. And the main speech was given by Lord Steyne. And can I take the court to page 25 at paragraph 28, where his lordship referred to Lord Keith's observations in Hill and commented just above E, nowadays a more sceptical approach to the carrying out of all public functions is necessary. But at paragraph 30, but the core principle of Hill has remained unchallenged in our domestic jurisprudence and in European jurisprudence for many years. If a case such as the Yorkshire Ripper case before the House in Hill arose for decision today, his lordship would have no doubt it would be decided in the same way. It is of course desirable that police officers should treat victims and witnesses properly and with respect, but to convert that ethical value into general legal duties of care on the police towards victims and witnesses would be going too far. The prime function of the police is the preservation of the Queen's peace. The police must concentrate on preventing the commission of crime, protecting life and property, apprehending criminals, preserving evidence. And then 3 lines from the bottom, a retreat from the principle in Hill would have detrimental effects for law enforcement. While focusing on investigating crime and the arrest of suspects, police officers would in practice be required to ensure that in every contact with a potential witness or potential victim, time and resources were deployed to avoid the risk of causing harm or offence. Such legal duties would tend to inhibit a robust approach in assessing a person as a possible suspect, witness or victim. By placing general duties of care on the police to victims and witnesses, the police's ability to perform their public functions in the interest of the community fearlessly and with dispatch would be impeded. It would, as was recognised in Hill, be bound to lead to an unduly defensive approach in combating crime. And there was a separate speech by Lord Bingham, and can I take the court to page 13 and pick that up at paragraph 2, page 13 at E, where Lord Bingham says, just above E, the only issue before the House is whether, assuming the facts pleaded to be true, the Commissioner and the officers for whom he's responsible arguably owed the respondent a common law duty sounding in damages to one, and then he sets out the three alleged duties of care, in particular one, to take reasonable steps to assess whether the respondent was a victim of crime, to accord him reasonably appropriate protection, etc., etc. And then at 3, for reasons elaborated at some length in his Lordship's dissenting opinion in D, his Lordship would be very reluctant to dismiss without any exploration of the facts a claim raised in a contentious and developing area of the law, where fuller factual inquiry might enable a claimant to establish a duty of care had been owed, and his Lordship would be reluctant to endorse the full breadth of what Hill has been thought to lay down, while readily accepting the correctness of the decision on its facts. 2 considerations, however, persuade me this appeal should be allowed, and the claims in common law negligence struck out. And the first, at paragraph 4, is that the facts have been exhaustively investigated. And then over the page, the second line, the second consideration is that the 3 duties pleaded are not, in his Lordship's opinion, duties which could even arguably be imposed on police officers charged in the public interest with the investigation of a very serious crime and the apprehension of those responsible. Even if it were thought, for reasons such as those touched on by Lord Steyn, that the ratio of Hill's case calls for some modification, I cannot conceive that any modification would be such as would accommodate the 3 pleaded duties. This is no criticism of the respondent's expert, but these are not duties which could be imposed on police officers without potentially undermining the officers' performance of their functions, effective performance of which serves an important public interest. This is a conclusive argument in the Commissioner's favour. So that was Brooks. The next case was Smith, which is in volume 2 of the authorities at tab number 13, and it begins at page 496. And the court will recall there were 2 cases before the appellate committee. One was the Van Colley case, and one was Smith. And it's Smith that we're concerned with in the present context. The facts of Smith are set out at the bottom of 496, letter H. The claimant reported to the police he had received persistent and threatening telephone, text, internet messages from his former partner following the breakup of their relationship, including threats to kill him. He provided the officers with details of his former partner's previous history of violence, his home address, the contents of the messages. The officers declined to look at or record the messages. They took no statement from him. They completed no crime form. They took steps to trace the calls, and they informed him of the progress of that investigation. Shortly thereafter, he was attacked at his home by his former partner, and he sustained severe and continuing injuries. And the question was whether there was a breach of any duty of care. And I'm plainly not going to read all of this. Can I identify for the court what we say are the central passages? Lord Hope at paragraph 75 on page 543. And this is an important paragraph in my submission because it addresses the point that there are real victims who suffer real wrongs for which they are claiming compensation. 75, the phrase, the interests of the whole community, was echoed in the last sentence of the passage which I've quoted from Lord Steyn's opinion in Brooks. there's an echo too in Brooks of the warning against yielding to arguments based on civil liberties. See the first sentence of that quotation where he warns against a retreat from the core principle. The point he was making in Brooks in support of the core principle in Hill was that the principle had been enunciated in the interests of the whole community. Replacing it with a legal principle which focuses on the facts of each case would amount, in Lord Steyne's words, to a retreat from the core principle. We must be careful not to allow ourselves to be persuaded by the shortcomings of the police in individual cases to undermine that principle. That was the very thing that he was warning against because of the risks that this would give rise to. As Lord Justice Ward said in another case, the greater public good outweighs any individual hardship. A principle of public policy that applies generally may be seen to operate harshly in some cases when they're judged by ordinary delictual principles. Those are indeed the cases where, as Lord Steyne put it, the interests of the wider community must prevail over those of the individual. And then at 76, he refers to a robust approach being necessary in assessing a person as a possible suspect or victim. At 78, over the page 544, Lord Hope says the test for the judge must be an objective one. How is the police officer to deal with evidence which, for one reason or another, he or she does not find convincing, but about which there's a risk that after the event a judge might take a different view? Subjecting the officer's judgment to an objective test would tend to lead to what Lord Carswell describes as defensive policing, focused on preventing or at least minimising the risk of civil claims in negligence. It could deny the police the freedom they need to act as the occasion requires in the public interest. In his lordship's opinion, the balance of advantage in this difficult area, and it is a difficult area, lies in preserving the Hill principle. In Brooks, Lord Nichols said there might be exceptional cases where the circumstances compelled the conclusion the absence of a remedy sounding in damages would be an affront to the principles that underlie the common law. I respect his approach, guard against the dangers of never saying never, but in my opinion, he says, the present case does not fall into that category. That's why if a civil remedy is to be provided, there needs to be a more fundamental departure from the core principle, and his lordship would resist this in the interests of the wider community. Lord Carswell, his reasoning is on page 550. I draw attention to 106. The principles in Hill were reviewed and affirmed in Brooks. Not necessary to depart from them. One must acknowledge at once that the price of the certainty of the rule and the freedom from liability afforded to police officers is that some citizens who have very good reason to complain of the police handling of matters affecting them will not have a remedy in negligence. One has to face this and decide whether in the wider public interest the law should allow that. And his lordship's opinion was that in the interests of the wider community it is necessary, it should do so for the better performance of police work. And over the page, 108 is to like effect. He refers to Lord Hope's opinion, paragraph 76. The factor of paramount importance is to give the police sufficient freedom to exercise their judgment in pursuit of their objectives to work in the public interest without being trammelled by the need to devote excessive time and attention to complaints or being constantly under the shadow of threatened litigation. Overreaction to complaints resulting from defensive policing is to be avoided just as much as failure to react with sufficient speed and effectiveness. One must also express the hope police officers will make good use of this freedom with wisdom and discretion, etc., etc. Lord Brown, his lordship dealt with the matter on page 555, and he emphasises two factors at paragraphs 132 and 133. 132 concern that the imposition of a liability principle would induce in the police a detrimentally defensive frame of mind. So far from doubting whether this would in fact be so, it seems to his lordship inevitable if liability could arise in this context, but not, of course, with regard to the police's many other tasks in investigating and combating crime, the police would be likely to treat these particular reported threats with especial caution at the expense of many other threats to life, limb and property of which they come to learn through their own and others' endeavours. More time and resources to investigation, take more active steps to combat them. They would be likely to arrest and charge more of those reportedly making the threats, more likely in those cases to refuse or oppose bail, etc., etc. And 133, the second public policy consideration is the desirability of safeguarding the police from legal proceedings which, meritorious or otherwise, would involve them a great deal of time, trouble and expense, more usefully devoted to their principal function of combating crime. And there's some further detail there. Lord Bingham dissented in that case, but he did so on the narrow ground that there was a close relationship of proximity between the victim and the police in the circumstances of that case. That's page 538, it's paragraph 60. On the assumed facts, His Lordship was satisfied that the liability principle that His Lordship had identified is satisfied. The police owed Mr. Smith a duty of care. He, a member of the public, furnished them with apparently credible evidence that Geoffrey, whom he identified, whose whereabouts were known, presented a specific and imminent threat to his life or safety. Not been argued, death or injury was not a foreseeable result. Relationship was one of close proximity based on direct face-to-face meetings. Going back, if I may, to Lord Torson, Volume 1 at tab 3 in Michael, His Lordship comprehensively then at paragraph 64, which is page 64, paragraph 64, page 64, dealt with a number of other cases, and the court can see those set out at paragraph 64 through to 95. I draw attention to the fact that at paragraph 96, which is on page 70, His Lordship referred to the present case. The claimants and the interveners relied on the judgment of Mr. Justice Green in the present case. The claimants were victims of a serial rapist. They succeeded in claims brought against the police under the Human Rights Act and Articles 3 and 8 of the Convention. There was no claim at common law. Mr. Justice Green carried out a detailed analysis of the Strasbourg jurisprudence. The claimants and interveners submitted. His analysis strengthens the case for a common law duty of the scope for which they respectively contend. That judgment is under appeal. And His Lordship came back to that later in his judgment, as I shall show the court. Then Lord Torson came to the substance of his own reasoning at page 74, at paragraph 115. His Lordship explained that to impose a liability on the police for a failure to safeguard victims of crime, the absence of any such duty is consistent with decisions of the courts not to impose a duty of care on other public bodies with discretionary powers. Then at 117, His Lordship dealt with the submission by Miss Monaghan, there appearing as here for an intervener. She'd advanced two arguments in support of the intervener's liability principle. She referred to the nature and scale of the problem of domestic violence, and she argued that the common law should be interpreted consistently with Articles 2 and 3 of the Convention. His Lordship recognised the shocking statistics, and at 119 over the page, if the foundation of a duty of care is the public law duty of the police to the preservation of the Queen's peace, it's hard to see why the duty should be confined to potential victims of a particular kind of breach. And that's 119, and similarly at 120, it's hard to see why it should be limited to particular potential victims, and there's some detail there set out. At 121, as to the argument that imposition of the intervener's liability principle should improve the performance of the police in dealing with cases of domestic violence, the court has no way of judging the likely operational consequences of changing the law of negligence in a way that is proposed. Mr. Bowen, who appeared for Miss Michael's estate, and Miss Monaghan were critical of Hill and other cases. Those criticisms have force, but the court would risk falling into equal error if it were to accept the proposition on the basis of intuition that a change in civil law would lead to a reduction of domestic violence or an improvement in its investigation. Failures in proper investigation can have disciplinary consequences, as there were in that case, and indeed in the present case, and it's speculative whether the addition of potential liability at common law would make a practical difference at an individual level to the conduct of police officers and support staff. At an institutional level, it is possible to imagine it might lead to police forces changing their priorities by applying more resources to reports of violence or threatened violence, but if so, it's hard to see it would be in the public interest for the determination of police priorities to be affected by the risk of being sued. The only consequence of which one can be sure is that the imposition of liability on the police to compensate victims of violence on the basis that the police should have prevented it would have potentially significant financial implications. The payment of compensation, costs of dealing with them, would have to come from the police budget with a corresponding reduction of spending on other services, or from an increased burden on the public from a combination of the two. Then his lordship turned to the argument based on the convention, and at 128 his lordship said it's unnecessary for the purposes of this appeal to decide questions about the scope of Article 3. His lordship would not wish to influence the Court of Appeal's consideration of the judgment in our case. It does not alter the essence of the argument which was considered and rejected by their lordship's house in Smith. I'm not persuaded, he said, it would be right for the court to depart from that decision, which itself was consistent with a line of previous authorities. Then at 130, his lordship dealt with the narrower liability principle for which Mr. Bowen was contending. If it's thought there should be public compensation for victims of certain types of crime above that which is provided under the Criminal Injuries Compensation Scheme, in cases of pure omission by the police to perform their duty, it should be for Parliament to determine whether there should be such a scheme, and if so, what should be its scope as to the types of crime, types of loss, and any financial limits. By introducing the HRA, a cause of action has been created in the limited circumstances where the police have acted in breach of Articles 2 and 3 or Article 8. There are good reasons why the positive obligations of the state under those articles are limited. And that's the issue in the present appeal. The creation of such a statutory cause of action does not itself provide a sufficient reason for the common law to duplicate or extend it. So that was the view of the majority, and I've already mentioned that my Lord Kerr dissented essentially on the basis that a duty of care did arise in that case because there was a sufficient proximity between the police and the claimant such as to make it fair, just and reasonable for there to be a duty of care. Paragraphs 149, 167 and 171. And my lady, the Deputy President's dissent was for similar reasons, in particular paragraph 197. So I say that the law, absent the Human Rights Act, has recognised and has repeatedly recognised at the highest appellate level that there is no duty of care on the police in relation to the performance of their investigative functions. And
As a matter of interest, Lord Panic, do you know what happened to the human rights claim in Michael?
No, but Mr. Johnson may.
Nothing's happened.
Nothing's happened.
Nothing's happened.
It hasn't been determined yet. It's yet to be determined. So the law recognises, it's repeatedly recognised at the highest appellate level, there's no duty of care on the police in relation to the performance of their investigative functions. There is, so all of those judgments recognise, leaving aside Hill from Brooks through Smith through to Michael, that there are reasons for concern, to put it at its very lowest, real reasons for concern, about consequences adverse to the public interest if such an investigative duty were to be introduced. The efficacy of investigations would, or at least may be, undermined. And
it's right to say, isn't it, that the policy reasons articulated in earlier cases were not espoused in any full-throated way by Lord Toulson.
Well, I've read, Your Lordship, all the paragraphs. I accept that the statements of public policy are certainly stronger in Brooks and in Smith. Lord Toulson does not dissociate the court from those, but his reasoning focuses on the absence of any basis for thinking that circumstances would be better, that investigations would more effectively be carried out if there were the liability for which the claimants contend. Of course, Michael was a case in which there was a very close relationship in principle between Ms. Michael and the police, and the case focused on that, and it focused also, the court will, my Lord will remember, it focused on the argument that was being put forward, which was essentially to accept that that Smith and Brooks may well be correct, but in the context of domestic violence offences and in the context of Ms. Michael having phoned the police and put her concerns to the police, there was a reason to adopt a different approach.
Right. But of their nature, public policy considerations which are prayed in aid in order to find that liability should not exist, of their nature call for re-examination and re-evaluation with increasing knowledge, with better evidence, and so on. You'd accept that as a general proposition, would you?
As a general proposition, yes, but the courts have looked at this matter now on many occasions.
Yes, but they have not spoken with one voice, Lord Panic.
No. Well, I say that there's been one voice in this sense, at the very least, that English law does not recognise an investigative duty. Different judges have put the reasons for that in different ways. But there are very strong statements of principle, which I've shown the courts, that there are strong public policy reasons why that should be so. And I think it's right to say that none of the judges that have addressed these issues have found in favour of a general investigative duty. That is a duty that does not depend upon a close relationship of proximity between the victim and the police, in the sense that the victim was saying to the police, I am in real danger, imminent danger. And Lord Bingham dissented in Smith for that reason. My Lord dissented and my Lady dissented in Michael for that very same reason. But the courts have spoken with one voice in relation to, is there a general investigative duty, a duty on the police, a private law duty, which sounds in damages, to an alleged victim of crime or a victim of crime who says to the police...
Well, I don't dissent from that. It was on the issue of public policy that I was addressing the point.
Well, I've shown the court
Yes.
the passages. I can't take it further than that. The question is whether or not Article 3, the Human Rights Act, should lead the court to a different conclusion. And
Can I just ask a question? You accept, don't you, in your case, written case, that there's a general substantive duty to have at least an efficient legal system?
Yes.
Has anyone ever gone to Strasbourg to say that because of the exclusion at common law of any liability on the part of police in cases like the Michael, the UK does not have an efficient legal system?
No.
I mean, be rather odd if that were not possible. I mean, it hasn't been tested, you're saying.
I'm not aware. No. I take your Lordship's point. Of course, it would be open, and that would cause the issue to be addressed. And there are cases, at least one of them, two of them concerning the United Kingdom, which I will show the court, where certainly that approach is not taken, that you can't sue for damages. That of itself is a breach. But I don't think it was argued. It wasn't argued like that.
If we had clear authority in Strasbourg that Michael is contrary to the convention, it would solve the present case, wouldn't it?
Well, only to this extent that if the European Court if the European Court were to take a different view to Michael, but to take it on the basis that there was, on the facts of that case, a close relationship.
Well, that's a different matter.
That would be a different matter.
Supposing they said that in general terms that this liability must exist,
yes.
Then one would have thought that would answer the position under the convention. If they said no, Michael is within the ambit of UK's responsibility. It'd be rather odd if they said, but nonetheless there's a liability under the
Well, I
Convention.
respectfully agree with you. I respectfully agree with your Lordship. And that's what Mr Eadie, on behalf of the Secretary of State of the United Kingdom, wants to have the opportunity to put to Strasbourg, that argument. But there's no case in which it has been addressed. Before I come to the Strasbourg case law, and that's the next subject, can I just mention one aspect of the judgment of Lord Justice Laws in the Court of Appeal? If I could take the court to page 4680, which is paragraph 11 of the Court of Appeal judgment, page 4680 in the core volume. And there's a criticism of the Metropolitan Police that I just need to make observations on. 4680, paragraph 11. His Lordship says, before he turns to the individual propositions, there's a broader point to be made. The restrictive reading, which the Metropolitan Police would attribute to Article 3, allows no real weight to be given to what may be thought of as fundamentals of a civilised constitution, the rule of law, and the security and protection of the people. And my respectful observation is that that is putting it a bit high. I mean, it's rhetoric, but with great respect, it is unjustified. And it's unjustified because the common law does not recognise, as I've shown at the court, an investigative duty. And I do not, of course, accept that the common law is for that reason inconsistent with the rule of law, security and protection. The law has a number of means by which it seeks to ensure that proper standards are maintained. So can I come to the Convention? Here the starting point we submit is that the case law has asserted that the meaning of the Article 3 obligation in the context of police investigation of crime is that there is an investigative duty in relation to misconduct by state agents, and the authority for that is Volume 3, the Azanoff case, at tab number 17. Page 697, my lady.
Yep.
Page 697, Volume 3, tab 17, page 697. And as the head note indicates, the context is that the first applicant was complaining about his alleged ill treatment by the Bulgarian police. The allegation was that the Bulgarian police had used violence on Bulgarian nationals of Roma origin, and there'd not been a proper investigation by the authorities into those allegations. And it's not about it. No. And at page 743 of the report of the judgment, if the court looks at paragraph 90, Mr. Azanoff was alleging that the events had given rise to violations of Article 3. He contended the article had been breached on two separate grounds. He asked the court to examine the medical evidence and the witness statements, which he said demonstrated he'd been severely beaten by police officers. And he asked the court to declare that wherever there were reasonable grounds to believe that an act of torture or inhuman or degrading treatment of punishment had been committed, the failure of the competent domestic authorities to carry out a prompt and impartial investigation in itself constituted a violation of Article 3. And the court addressed that issue at paragraph 101 and 102. 101, the court considers that the medical evidence, the fact that he was detained, any lack of any account from any witness of Mr. Ivanov beating his son with sufficient severity to cause the reported bruising, together raise a reasonable suspicion that these injuries may have been caused by the police. And then over the page 746, paragraph 102, the court considers in these circumstances where an individual raises an arguable claim that he's been seriously ill-treated by the police or other such agents of the state, unlawfully and in breach of Article 3, that provision, read in conjunction with the state's general duty under Article 1 to secure to everyone within their jurisdiction the rights and freedoms in the Convention, requires by implication there should be an effective official investigation. This obligation, as with Article 2, should be capable of leading to the identification and punishment of those responsible. If this were not the case, the general legal prohibition of torture and inhuman and degrading treatment and punishment, despite its fundamental importance, would be ineffective in practice, and it would be possible in some cases for agents of the state to abuse the rights of those within their control with virtual impunity. So in two places, in the third line and 3 lines from the end, the principle is defined by reference to agents of the state. And that, we say, is not surprising, because the substantive Article 3 obligation is concerned with ill treatment by agents of the state. It's not concerned with ill treatment by private individuals. This principle has been stated in the same terms by the European Court in later cases, 2 of which are Grand Court judgments. The first of them is also volume 3. It's tab number 23, and it's page 937, and it's the case of Gafgen, a particularly horrible case, as the court will see. In 2002, the applicant abducted a child, suffocated him, and subsequently demanded a ransom from the child's family. The applicant disposed of the corpse, collected the ransom payment, and was subsequently arrested by the police. While being questioned, he was threatened by a police officer with physical harm if he did not reveal the location of the body. As a result of the threats, the applicant confessed. He subsequently disclosed the location of the child's body, and the police recovered the corpse and secured further evidence. And then at the bottom of the page, H4, the applicant applied to the Strasbourg court and relied upon Article 3. He said he'd been subjected to torture during his questioning, and then there was also a fair trial point, and the case was before the Grand Chamber. Judge Bratzer was one of the members of the Grand Chamber, and the court set out the relevant principle at 117, starting at 117 on page 966. As regards the requirement of a thorough and effective investigation, the court reiterates that where an individual raises an arguable claim that he's been seriously ill-treated by the police or other such agents of the state, unlawfully and in breach of Article 3, that provision, read in conjunction with the state's general duty under Article 1, requires by implication that there should be an effective official investigation. Such an investigation should be capable of leading to the identification and punishment of those responsible. For an investigation to be effective in practice, it is a prerequisite the state has enacted criminal law provisions penalising practices contrary to Article 3. And then again at 119, in cases of willful ill treatment, the breach of Article 3 cannot be remedied only by an award of compensation to the victim. This is so because if the authorities could confine their reaction to incidents of willful ill treatment by state agents to the mere payment of compensation, while not doing enough to prosecute and punish those responsible, it would be possible in some cases for agents of the state to abuse the rights of those within their control with virtual impunity, and the general legal prohibition of torture and inhuman and degrading treatment, despite its fundamental importance, would be ineffective in practice. And I should have mentioned in paragraph 117, footnote 75 is to the Azanoff case, which I had shown to the court. So that's the first Grand Chamber judgment which uses the Azanoff rubric. The other Grand Chamber case on the scope of the investigative duty to which I draw attention is in the same bundle. It's tab 22 and it's page 858. This is the El Masri case before the Grand Chamber President, Judge Bratzer. This case concerned a complaint of extraordinary rendition to Afghanistan. The allegation was that the applicant had been returned to Afghanistan or sent to Afghanistan by the CIA with assistance from agents of the former Yugoslav Republic, and the relevant principle was stated by the Grand Chamber at page 913. At the bottom of 913, it's paragraph 182 under the heading Procedural Aspect of Article 3, Lack of an Effective Investigation, General Principles. 182, the court reiterates where an individual raises an arguable claim that he has suffered...
Which paragraph is it?
Paragraph 182.
182. Thank you very much. I have it. Yep. Thank you.
The court reiterates where an individual raises an arguable claim that he has suffered treatment infringing Article 3 at the hands of the police or other similar agents of the state. And then there's what the court has already seen. And at the end of paragraph 182, again, there's a reference to it would be possible, if this isn't right, in some cases, for agents of the state to abuse the rights of those within their control with virtual impunity. So, two Grand Chamber judgments stating the principle in that restricted way.
Stating a general principle in the sense that it's any conduct, isn't it, by a state agent?
Yes.
So it's not restricted to something which might be regarded as involving a systematic failure by the state.
No, but
if you just had one police officer beating up someone in a cell, quite contrary to orders, that would nonetheless be investigated, required to be investigated.
Yes, because there are various ways in which the state can breach Article 3. One of them is if agents of the state carry out activities which reach the inhuman or degrading treatment or punishment threshold, and that may be one rogue police officer beating up the suspect. That's one example. Another example, and I'm coming to this, is where the state doesn't have proper laws. A third example is the example that Your Lordship puts me at the beginning of this afternoon under the protective duty.
Which is, I mean, the protective duty, the trouble is there are all sorts of adjectives floating around, but isn't that part of the same as having a proper legal system? Isn't that an aspect of the protective duty?
Well, it's an aspect of that, but you could have a proper legal system and yet, in the circumstances of a particular case...
Osman-type case, yes.
Yes, and that sort of case is the Osman case. Perhaps we could just very briefly look at that. Volume 4, and it's tab number 32, Osman and the United Kingdom, and the relevant principle, I won't bother, if Your Lordship's Lordship will forgive me, I won't bother with all the detail, that the Osman case, the principle is set out at page 1382 in the context of Article 2, but it's a similar principle that we accept for Article 3. 1382, and in paragraph 115, in the second part of 115, the court says, and this is the Grand Chamber, this is page 1382, second part of paragraph 115, it's thus accepted by those appearing before the court that Article 2 may also imply in certain well-defined circumstances a positive obligation on the authorities to take preventive operational measures to protect an individual whose life is at risk from the criminal acts of another individual. The scope of this obligation is a matter of dispute between the parties. 116, for the court, and bearing in mind the difficulties involved in policing modern societies, the unpredictability of human conduct, and the operational choices which must be made in terms of priorities and resources, all of that an indication that the European Court is not immune to those considerations. Such an obligation must be interpreted in a way which does not impose an impossible or disproportionate burden on the authorities. Accordingly, not every claimed risk to life can entail for the authorities a conventional requirement to take operational measures to prevent that risk from materialising. And then in the next sub-paragraph, in the opinion of the court, where there is an allegation that the authorities have violated their positive obligation to protect the right to life in the context of the above-mentioned duty to prevent and suppress offences against the person, it must be established to its satisfaction that the authorities knew or ought to have known at the time of the existence of a real and immediate risk to the life of an identified individual or individuals from the criminal acts of a third party, and that they failed to take measures within the scope of their powers which judged reasonably might have been expected to avoid that risk. So it's a very specific obligation in the circumstances of particular cases. There's also the obligation to have a proper legal system, one with proper laws, and perhaps the best example of that is the corporal punishment case, volume 2, tab 15, at page 645.
Yep.
And the court sees from the head note, the applicant, a child, was severely beaten by his stepfather with a garden cane. At the trial, the stepfather pleaded reasonable chastisement and he was acquitted of assault. The child claimed under Articles 3 and 8 that the state had failed to protect him from ill treatment by his stepfather, and the court unanimously found a breach of Article 3, and the substance of it appears at page 663. And at paragraph 20, there's the very familiar principle that ill treatment must attain a minimum level of severity if it's to fall within the scope of Article 3, and it all depends. Paragraph 21, the sordid facts are set out. At 22, it remains to be determined whether the state should be held responsible under Article 3 for the beating of the applicant by his stepfather. The court considers that the obligation on the parties under Article 1 to secure to everyone within their jurisdiction the rights and freedoms defined in the Convention, taken together with Article 3, requires states to take measures designed to ensure that individuals within their jurisdiction are not subjected to torture or inhuman or degrading treatment or punishment, including such ill treatment administered by private individuals. Children and other vulnerable individuals in particular are entitled to state protection in the form of effective deterrence against such serious breaches of personal integrity. And then at 23, the court comments on English law, that is the defence of reasonable chastisement and the burden of proof. And at 24, in the court's view, the law did not provide adequate protection to the applicant against treatment or punishment contrary to Article 3. Indeed, the government have accepted that this law currently fails to provide adequate protection to children and should be amended. So you need to have a proper substantive legal provisions to satisfy Article 3. Now, the respondent's case is that all of this is correct, but it doesn't go far enough because the Strasbourg case law recognises a broader investigative duty. And the foundation of their submission is the decision of the section of the court in MC and Bulgaria, which can be found in volume 4 at tab number 27, page 1158. And the head note tells us that the complaint from the applicant, page 1158, the applicant was complaining that when she was age 14, she was raped by two men, P&A, but their defence was that she had consented to sexual intercourse. And at the end of H1 on that page, 5 lines up from the end of H1, the district prosecutor issued a decree terminating the criminal proceedings, that's the proceedings against P&A. He found that the use of force or threats had not been established beyond reasonable doubt, and in particular, that no resistance on her part or attempts to seek help from others had been established. And relying upon Article 3 and other provisions, she complained that Bulgarian law and practice did not provide effective protection against rape and sexual abuse, as only cases where the victim had actively resisted were prosecuted. The deficient nature of Bulgarian law, certainly at that time, is set out on page 1170. Paragraph 74, the court sees the criminal code in Bulgaria. It defined rape as sexual intercourse with a woman, one, incapable of defending herself where she did not consent, who was compelled by means of force or threats, or who was brought to a state of defencelessness by the perpetrator. And at 77, the court comments, therefore, an accused person may be found guilty of rape only if it has been established that he had sexual intercourse with a woman in circumstances covered by one of 3 subparagraphs. And at 79, the courts, that's the Bulgarian courts, have stated that a victim is in a helpless state only in circumstances where she has no capacity to resist physically, owing to disability, old age or illness, or because of the use of alcohol, medicines or drugs. The second subparagraph is the provision applicable in all other cases of alleged rape. Thus, where no special circumstances, such as the helpless state of the victim, are reported, an investigation into an alleged rape will concentrate on establishing whether or not the victim was coerced into having sexual intercourse by the use of force or threats. And that, as this court will see, is what was offensive under Article 3. So if we come to the court's assessment, which begins on page 1185, at paragraph 150, the court refers to the positive obligations on the state being inherent under Article 8, while the choice of the means to secure compliance with Article 8 in the sphere of protection against acts of individuals is in principle within the state's margin of appreciation. Effective deterrence against grave acts such as rape, where fundamental values and essential aspects of private life are at stake, requires efficient criminal law provisions. Children and other vulnerable individuals in particular are entitled to effective protection. Then this, 151, in a number of cases, Article 3 gives rise to a positive obligation to conduct an official investigation. And the footnote reference is to Azanov, which is the state agent's case. It goes on, such positive obligations cannot be considered in principle to be limited solely to cases of ill treatment by state agents. So here's the point of departure. And there's a footnote reference, si mutatis mutandis, Calvelli and Siglio against Italy. And breaking off there might just be helpful to look at that case, which is in volume 3 of the authorities at tab number 20.
Thank you.
Page 821.
Yep.
This was a Grand Chamber judgment, and it concerned alleged medical negligence, which resulted in the death of a newborn baby, and it was an Article 2 case. And the problem...
Do you say there's any difference between Article 2 and 3, Ms. Arrow?
Do I say there's any difference?
Yes.
No, I'm not suggesting in this context that there's...
Because we don't seem to have in the papers here Middleton, for example, which had discussed the Article 2 context and discussed the issues that it's referred to in
Yes.
Smith.
We have
and
some of the Article 2 cases, and I'm going to take the court, in particular to Menson, But I will
The
come to that.
passage in Middleton's actually referred to in Smith and the Oxfordshire coroner.
Indeed.
So that we can look at it.
Indeed. Calvelli is an Article 2 case, and the problem in Calvelli was that there was a time bar which meant that it was impossible to prosecute the doctor who was said to be responsible for the death of the newborn baby. And that was said to amount to a violation of Articles 2 and 6. And the court sees that at page 828, paragraph 41. The applicants complain firstly of a violation of Article 2 on the ground that owing to procedural delays, a time bar had arisen, making it impossible to prosecute the doctor responsible for the delivery of the child.
Is this one of these Italian cases where the period of limitation runs out sometime after the trial, but pending the appeal?
I can't remember whether that was the facts here or not.
Oh, right, doesn't matter anyway.
But it was the issue was a time bar issue. Yeah. And paragraph 58, there was also a complaint about the length of proceedings, and we're not concerned with that. The Grand Chamber held that there was not a breach of either Article 2 or Article 6. And in relation to Article 2, the relevant paragraphs begin at 48, which is on page 830. 48, the court reiterates the first sentence of Article 2, which ranks as one of the most fundamental provisions in the Convention, enshrines one of the most basic values of democratic societies, making up the Council of Europe, enjoins the state not only to refrain from intentional taking of life, but to take appropriate steps to safeguard the lives within its jurisdiction. 49, these principles apply in the public health sphere too. The positive obligations require states to make regulations compelling hospitals, whether public or private, to adopt appropriate measures for the protection of their patients' lives. They require an effective independent judicial system to be set up so that the cause of death of patients in the care of the medical profession, whether in the public or private sector, can be determined and those responsible made accountable. And then the court turned to compliance, and at 54, the court notes the criminal proceedings instituted against the doctor concerned became time-barred because of procedural shortcomings that led to delays, particularly during the inquiry and judicial investigation. However, the applicants were also entitled to issue proceedings in the civil courts. That is what they did. It's true, no finding of liability was ever made against the doctor by a civil court. However, the case file shows that in the civil proceedings, in the court of first instance, the applicants entered into a settlement agreement with the doctors and the clinic's insurers and voluntarily waived their right to pursue those proceedings. This could have led to an order against the doctor for the payment of damages. That's why I showed this court that damages were obtained against war boys in the circumstances of this case. And then the last line on that page, as the government have indicated, a judgment in the civil court could also have led to disciplinary action against the doctor. Well, their disciplinary proceedings, of course, are available against police officers, and that occurred in this case. The court accordingly considers that the applicants denied themselves access to the best means, and one that in the special circumstances would have satisfied the positive obligations of elucidating the extent of the doctor's responsibility for the death of their child. In that connection, the court reiterates that where a relative of a deceased person accepts compensation in settlement of a claim based on medical negligence, he or she, in principle, is no longer able to claim to be a victim. And I've read all that out, my lords, my lady, because it's absolutely nothing to do with the investigative duty. And that, of course, is what the section of the court in MC was addressing. So if we go back to MC at volume 4, tab 27,
Yep.
I'd taken the court to paragraph 151,
Yes.
and the second sentence of that, the authority that he's given for expanding the investigative duty simply, in my submission, doesn't assist. At 152, further, the court has not excluded the possibilities that the state's positive obligation under Article 8 to safeguard the individual's physical integrity may extend to questions relating to the effectiveness of a criminal investigation. And the footnote reference for that is the Osman case.
Yeah.
And if we go back to Osman, it's same volume 4.
Yep.
It's tab 32.
Yep.
And the passage that is referred to, paragraph 128, appears on page...
1387.
Your Lordship is ahead of me. 128.
1387.
128 appears on page 1387. And 128, the court recalls that it has not found it established that the police knew or ought to have known at the time that Paget Lewis represented a real and immediate risk to the life of Ahmed Osman, and that their response to the events as they unfolded was reasonable in the circumstances and not incompatible with the authorities' duty under Article 2 to safeguard the right to life. In the court's view, that conclusion equally supports the finding there's been no breach of any positive obligation implied by Article 8 to safeguard the second applicant's physical integrity. Again, it's very difficult to see how that assists in relation to the point that the section of the court is making at 152. And then at 153 of MC, back to tab 27, page 1186, the court tells us on that basis, we respectfully ask what basis, the court considers that states have a positive obligation inherent in Article 3 and 8 to enact criminal law provisions effectively punishing rape and to apply them in practice through effective investigation and prosecution. And we say that is a major leap which is simply unsupported by any coherent analysis.
Well, why is that so? If you've got to have a proper legal system,
Yes.
Said to be an efficient legal system, laws by themselves do not do the whole trick. You need to enforce it, and you need to, don't you need, therefore, to investigate occurrences with a view to prevention as well as simply with a view to punishment of the particular offence?
Well, it's one thing, in my submission, it's one thing to say that you have to have appropriate laws and that it's not open to the state simply not to enforce them. I entirely accept that. It wouldn't be open to the state to say, well, we're not going to conduct investigations, or for an individual police officer to say, I'm not going to conduct an investigation. But it's quite another, in my submission, to say that it's the role of the Strasbourg Court under Article 3 to assess whether on the facts of a particular case the investigation has been conducted in an efficient manner, whether or not that has occurred. That's an entirely different question. And when I criticised in my submissions the European Court for failing to give any explanation, I do respectfully submit that 151 and 152 do not provide any basis for departing from Azanov, which states the principle by reference to wrongdoing by agents of the state.
To make good those propositions, you rely on the misapprehension of the Chamber as to the aptness of the cases in the footnotes 34 and 35. If one leaves those out of account, is there anything wrong with the statements contained in 34 and 35?
Well, I don't accept 151's second sentence. Such positive obligations cannot be considered in principle to be limited solely to cases of ill treatment by state agents. That's exactly what the court said in Azanov and repeated.
In the cases that you took us through, beginning with Azanov, in fact, state agents were involved in every case.
Yes, they were. I accept that. But the principle, as stated in Azanov and as repeated in El Nasri and in the Gafgen case, stated the principle repeatedly, I say deliberately, by reference to the conduct of state agents, and did so because the substantive obligation under Article 3 is that agents of the state, not private individuals, agents of the state, may not carry out activity which amounts to inhuman or degrading treatment of punishment. I accept that that is not the only obligation of the state. There are different principles. The protective principle, if the state knows or has good reason to know that a particular specific individual is under risk, the state must act. And I accept also that the state, see the case of A against the United Kingdom, must have a proper system of laws.
But in none of the cases to which you have referred us, was the court required to, nor did it directly address the possible extension of this species of liability to non-state agents?
I accept that as well, my Lord. I entirely accept that. And if one
The
goes...
real problem with this is, at the very lowest, it's a mixing up of all sorts of different concepts which arise under Article 2 or Article 3, and they need to be separated out. It's not very helpful to cite one in support of another.
I entirely accept that, and I would respectfully add to that, all of it arises in a case, MC, where at least a very substantial part of the mischief was that Bulgaria did not have proper laws. The laws that addressed rape were, by Article 3 standards, woefully deficient because they did not make what we would all recognise to be rape a criminal activity in Bulgaria. And one sees that if one goes on in the report, page 1187.
I don't think you've got a problem personally on that, but the problem is where does it stop? I repeat, really, it's not good enough to say the laws are okay if the legal system, and how widely we define the legal system is probably a relevant question, isn't working. Does it include the police? Are laws simply there to punish, or aren't they also there to deter and prevent, and so on?
Well, they're certainly there to deter and to prevent. And how far along the road one travels was addressed in another case that I'm coming to, which I say gets closer to what we submit should be the proper test. But can I just finish MC and just show the court the remaining relevant paragraphs? 167, in the light of, this is page 1187, in the light of the above, the court's task is to examine whether or not the impugned legislation and practice and its application in the case at hand, combined with the alleged shortcomings in the investigation, had such significant flaws as to amount to a breach of the respondent's positive obligation. The issue before the court is limited to the above. The court is not concerned with allegations of errors or isolated omissions in the investigation. It cannot replace the domestic authorities in the assessment of the facts of the case, nor can it decide on the alleged perpetrator's criminal responsibility. And 169, the applicant alleged that the authorities' attitude was rooted in defective legislation and reflected a predominant practice of prosecuting rape perpetrators only in the presence of evidence of significant physical resistance, and we respectfully agree. On page 1190, paragraph 182, the court finds that the failure of the authorities in the applicant's case to investigate sufficiently the surrounding circumstances was the result of them putting undue emphasis on direct proof of rape. Their approach in the particular case was restrictive, practically elevating resistance to the status of the defining element of the offence. And 184, there were significant delays. 185, in sum, the court, without expressing an opinion on the guilt of P&A, finds that the effectiveness of the investigation of the case, and in particular the approach taken by the investigator and the prosecutors in the case, fell short of the requirements inherent in the state's positive obligations viewed in the light of the relevant modern standards in comparative and international law to establish and apply effectively a criminal law system punishing all forms of rape and sexual abuse. And that's what the case is really about. I do submit, with greatest respect to that section of the court, it is a very, very confused analysis of the issues. Now, The court has applied MC in a number of later cases, and there are two further Grand Chamber judgments which have been handed down. One of them approves a decision of a section of the court in a case called CAS and Romania, and it's convenient, I hope, to go to that first before coming to the other two Grand Chamber decisions. Volume 3, tab 21, at page 841, this is a section of the court, page 841, volume 3, tab 21. The first applicant was a 7-year-old boy. He'd allegedly been subjected to repeated rape and violence at home by PE, who threatened to kill him if he told anyone. The applicant eventually told his family what was happening, and the matter was reported to the police. And if the court goes to paragraph 36, which is on page 846, the court will see that part of the complaints were about the investigation. Paragraph 36, throughout the investigation and prosecution, the second applicant complained several times about the length of the proceedings. His complaints were dismissed by the prosecutor's office. The second applicant complained that he, his family, and some of the witnesses had received threats from PE, and they reported the incidents to the police. And then there was a complaint about the prosecutor's decision not to bring prosecution. So that was part of the case. And at paragraph 69, which is on page 853, the principle is stated, furthermore, the absence of any direct state responsibility for acts of violence that meet the condition of severity, such as to engage Article 3, does not absolve the state from all obligations under this provision. In such cases, Article 3 requires that the authorities conduct an effective official investigation into the alleged ill treatment, even if such treatment has been inflicted by private individuals. And there's a footnote reference to MC, which the court has seen, and to another case to like effect. And then at paragraph 74, the court will, which is on page 854, the court will see how woefully inadequate the investigation was. It took 5 years, and for 3 years, no significant investigative steps were taken. At 77, the court reiterated it's not concerned with allegations of errors or isolated omissions in the investigation. It cannot replace the domestic authorities in the assessment of the facts of the case, cannot decide on criminal responsibility. It's for the authorities to explore the facts. 78, notwithstanding its subsidiary role, the court is particularly concerned the authorities did not try to weigh up the conflicting evidence. They made no consistent efforts to establish the facts by engaging in a context-sensitive assessment. And then at 82, the court points out the obligations incurred by the state require the best interests of the child be respected. The right to human dignity and psychological integrity requires particular attention where a child is the victim of violence. And at 83, the failure to adequately respond to the allegations of child abuse raised doubts as to the effectiveness of the system put in place by the state in accordance with its international obligations, and that's sufficient to enable the court to conclude the authorities failed to meet their positive obligations to conduct an effective investigation. So it's a case about children, and it's a case where the authorities essentially did nothing or very little in relation to the matter. Now, that case has been approved, and the terms of approval are important, by the Grand Chamber, and the relevant authority is O'Keefe, which is volume 4, and it's tab number 31, page 1252. It's a Grand Chamber judgment, and the circumstances are sadly familiar. The applicant attended a school. The school was owned by the Catholic bishop of the diocese. The manager who acted on behalf of the bishop was the local parish priest. A local priest was the de facto manager. And in 1971, a complaint of sexual assault was made to the manager against the principal. And the complaint was not reported to the police, the Department of Education and Science, or any other state authority. It was not acted upon by the manager. And in 1973, the applicant was sexually assaulted on 20 occasions during music lessons. The applicant and her parents were unaware of the earlier allegation in 1971. The parents then became aware of similar allegations, and the allegations were not reported to the police still. LH subsequently taught in another school. No complaint was made. And then matters come to light. The applicant made a statement to the police in 1997. LH was charged with 386 offences of sexual abuse. He pleaded guilty, was sentenced to imprisonment, and his licence to teach was withdrawn. And then over the page, the applicant instituted civil proceedings against LH and also against the state bodies, claiming damages, claiming for negligence as a result of failure to recognise, examine and supervise the school. Constitutional rights were also relied on, and vicarious liability. And those claims failed. See H6. Supreme Court dismissed the appeal on the basis the state defendants were not liable for the actions of LH, and the minister's absence of direct control prevented a finding against the minister. The manager was an agent of the church, not the minister. It was the manager and the patron who ran the school. They had the power to put effective measures and procedures in place, not the minister. And the finding of the court was that there had been a violation of the substantive aspect of Article 3 and a breach of Article 13 with Article 3 because of a lack of effective remedy. And if the court, please, will go to 144, paragraph 144, the court addresses the positive obligations of the state. The court can see how that is put. And at the end of 144, the last four lines, however, the required measures should at least provide effective protection, in particular of children and other vulnerable persons, and should include reasonable steps to prevent ill treatment of which the authorities had or ought to have had knowledge. And at 146, it's an inherent obligation of government to ensure their protection, that's children's protection, from ill treatment, and that was an obligation that applied at the relevant time. And at 168 through to 169, the court found that that substantive obligation had been breached. And then at 170, the court turns to the procedural obligations under Article 3. And it's 172. The court recalls the principles outlined in CAS and Romania. That's the case I've just shown at this court. To the effect that Article 3 requires the authorities to conduct an effective official investigation into alleged ill treatment inflicted by private individuals, which investigation should in principle be capable of leading to the establishment of the facts of the case and to the identification and punishment of those responsible. That investigation should be conducted independently, promptly, and with reasonable expedition. The victim should be able to participate effectively. The existence of adequate detection and reporting mechanisms has been examined above in the context of the positive obligations of the state under the substantive aspect of Article 3. Thereafter, the procedural obligations arise once a matter has been brought to the attention of the authorities. So that's when the procedural obligation arises. In the present case, once a complaint about sexual abuse was made, an investigation opened. The applicant was contacted. LH was charged. He was convicted and imprisoned. It's not clear from the submissions whether the applicant's case was included in the sample charges. However, she did not take any issue with the fact that LH was allowed to plead guilty to representative charges or with his sentence. Any question concerning her inability to obtain recognition of and compensation for the state's failure to protect falls to be examined below under Article 13 in conjunction with Article 3. And over the page, for these reasons, the court finds there's been no violation of the procedural obligations. Now, I say that strongly suggests that for the Grand Chamber, the procedural obligation is based on the substantive obligations of the state under Article 3.
But that isn't that well established. Those two are correlative. But surely under chapter 2 of this judgment, which is dealing with the general protective obligation,
Yes.
the positive obligation, paragraph 168 is dealing with investigation, amongst other things, the failure of which failed to protect. Look
Yes.
at the consequences with a failure by the non-state manager to act on prior complaints of sexual abuse must be considered to have failed to fulfil its positive obligation to protect. Why isn't that the substantive obligation which is an issue in the present case?
Because the court, in my submission, goes out of its way to emphasise that positive obligation is not an obligation owed to everyone, it is an obligation owed to children and other vulnerable persons. That's 144 and 145 and 146 and 147. If we go back to page 1284, the court sets out the general provisions relating to Article 3, and at the end of 144, the last 4 lines, the measures should at least provide effective protection, in particular of children and other vulnerable persons, and should include reasonable steps to prevent ill treatment which the authorities had or ought to have had knowledge.
Women in taxis at night?
I'm sorry, my Lord.
Women in taxis at night, isn't that a relevant area of protection if you find that they're being exposed to alleged assaults?
Well, I don't accept when the court is talking in paragraph 144 of children and other vulnerable persons that what it means is that anyone whose circumstances are in fact vulnerable, they are in danger, the court has a role under the substantive provisions of Article 3. What it is focusing on are the particular international obligations of the state in relation to children. And that's what the court deals with at paragraph 147. All of the court's analysis of the international obligations of the state relating to children would be unnecessary if it were the position that under Article 3 the state has a substantive protective role in relation to all persons who may suffer harm. Indeed, this would swallow up entirely the Osman principle that the state only has the protective obligation if it knows that a specific individual faces a real and imminent danger from another specific individual. That's the whole point.
How does this relate, Lord Panic, to the kinds of case that one comes across in the immigration or extradition context, where the question is not whether somebody is going to be persecuted or tortured by the state if he's returned, but that he's going to be at risk of similar treatment from private individuals, gangs or whatever, and the state simply doesn't have sufficient protective means in place. Quite used to that, aren't we, without it being confined to children or specifically
Your
vulnerable
Lordship
people.
is correct. In that context, the state, if it's going to take the measure, but the state is involved at that level. The state is taking, this state is taking a step of returning someone to a foreign land.
So it's this state's actions which exposes him to the risk.
Well, in my submission, yes.
I see.
And your Lordship's absolutely right, of course, that it's no answer to say, well, the risk that is going to be met abroad is a risk carried out by private individuals, but it's still the conduct of this state in returning the person, which is that which is being challenged. But the
In
general...
any event, this is protection.
Yes.
Investigate. First of all, do you say investigation is part of protection?
I say it's a different principle.
Yes, I thought
You do say that, yes.
But
We're having a little bit of difficulty getting our heads round it.
Yes.
there are various
Failure to act
strands.
on and protect. I thought that was investigation.
Well, there are various strands of principle that the European Court has set out, and I've accepted the Osman principle. If you know that there is a real and immediate threat to a specific individual, the state...
Well, then you have to do something to protect that individual.
Indeed.
You've got a general obligation
Indeed.
to have a system of criminal laws, criminal investigation, effective policing to protect everybody from ill treatment or risks to death, risks to life. So you've got the general systematic obligation, which Osman recognises. You've got the operational duty, which Osman recognises if you know of a real and immediate blah, blah, blah. And you've got the investigative obligation, which might stem from either of those. Yeah. That's what we're trying to look at.
Indeed. And the question in this case is the extent to which the investigative duty is breached by reason of a failure in the circumstances of a particular case, where the state does have, as I say it has here, perfectly adequate laws, and it has a system which addresses the mischief in a variety of ways. It allows for criminal prosecutions, it allows for disciplinary actions against the police, it allows for tort claims against the wrongdoer, it allows for compensation under the Criminal Injuries Compensation Scheme. And the question is whether Article 3 also requires that if the investigation is not carried out in a satisfactory manner above the level of individual errors or omissions, because that's not covered.
Beyond that.
But something more than that, but something less than not having the laws in the first place or not carrying out the investigation at all, whether there is liability. And my submission on O'Keefe, which is a Grand Chamber judgment, I say that O'Keefe helps us rather than my friend, because it pins the investigative obligation to the substantive obligation, which is, in terms of O'Keefe, not a substantive obligation to all members of the community, but it is defined by reference to the state's obligation to protect children and other vulnerable persons. And vulnerable
I wonder, is that right?
There
I mean, it has to be set in context.
Yes.
I mean, the passage on which you fasten, namely the final sentence in 144, is preceded by the statement that Article 3 requires states to take measures designed to ensure that individuals within their jurisdiction are not subjected to torture or inhuman. And then if you look at the sentence on which you particularly rely itself, the required measures should at least provide effective protection in the particular of children and other vulnerable persons. It's not confining it to
No, I
those
appreciate
groups.
that. I simply emphasise that when the Grand Chamber, in the context of sexual abuse of children, comes to look at this matter, it does not clearly assert that there is an investigative duty owed in all circumstances. What it does is to draw specific attention to the circumstances relating to vulnerable persons who are children. And that's why I say the Grand Chamber has not approved the MC principle in its full glory. It has held back from that. It has recognised that there can be circumstances where an investigative duty is owed, but it's put it by reference to the particularly vulnerable person. And the final Grand Chamber judgment that the court may wish to be aware of, I'm not aware of any others that are relevant is S and Sweden. And
Well-
that one can be found in volume 11.
We'll look at that, of course, immediately.
Yes.
But it occurs to me that if you are arguing for a link between the investigative duty and the substantive duty, which
Yes.
seems pretty apparent, it will be not unhelpful to look at cases like Opus and Turkey, which said that there was a substantive duty to protect against domestic violence. So obviously, seeing women in particular who are at risk of domestic violence as being people who, to whom positive substantive obligations are owed.
In particular circumstances. They're not
Yes.
a general duty. I need Opus and Turkey. This was a case where the domestic authorities had not taken adequate steps to protect the victim given earlier threats. It's not concerned with investigative duties. These are...
No, I didn't say it was.
No, I'm not suggesting...
I was not saying that.
I'm
But
just
what I
making
was
my-
challenging was your limitation
No.
of the scope of the substantive protective duties.
No, I entirely accept that where the state knows or has reason to know that particular people are vulnerable, then the state may well have does have a substantive duty to step in and protect them.
That's the Osmond case.
Yes, and Opus is an example of that. It's a case where the domestic authorities knew of earlier threats. These women had been threatened, and the state had not stepped in to protect them. Now that's, I say, perfectly understandable. It doesn't challenge, in my submission.
What you're saying is that there are specific cases and then there are category cases.
Yes.
The category cases include children,
Yeah.
but they don't, you say, include women in...
Well, I'm seeking to the thrust of my submission is that the substantive protection under Article 3 has expanded, and there are various limbs of it, but it doesn't go so far as to establish that where the ill treatment is carried out by a private individual, here war boys, and the state did not know of the specific threat to particular injuries, that there's a substantive obligation. And in that context, the question that arises is there an investigative duty when the state is told, and how far does it go? That's the question.
So it has to be personalised to the individual.
Well, the protective duty, in the Osmond sense, is personalised.
I just wonder why the Grand
there's a
Chamber
reason.
used other vulnerable persons.
There's a reason for that. The reason why the Grand Chamber in Osmond sets out those criteria, and their narrow criteria, is precisely because the Grand Chamber does not want to go to the extent of recognising under Article 3 a broad, general protective duty on the state in all circumstances. The obligations of the state are confined, and understandably so, to circumstances where the state either knew or it ought to have known of the specific threat, specific in the sense that a particular individual is vulnerable.
Why understandably so? I mean, we're talking about threats to life and threats of really serious
Yes.
bodily injuries. So we're not talking about every cut and graze or
No.
or even broken leg.
That's true.
Why shouldn't the state be expected to be efficient by the Strasbourg court and not just to be reactive to particular knowledge of a particular threat, for example?
Because in my submission, the state enjoys a margin of appreciation in the way that it implements Article 3 in cases where it doesn't have knowledge of the threats of the particular individual. And we are entitled to adopt the approach that the series of provisions that we adopt are sufficient to meet those obligations, albeit there will be hard cases. It's inevitable. And for public policy reasons, our law, our parliament, is entitled to adopt that approach, particularly in a case, and I'll come to this, particularly in a case where the individual was convicted at the end of the day, and I'll show the court why that matters in the authorities, and particularly in a case where the victims have been compensated. They haven't been left uncompensated. They have received compensation from the wrongdoer and from the Criminal Injuries Compensation Fund. But can I just show...
Then take us to S and Sweden.
Yes, please, if I may, very briefly. Volume 11, tab 101.
3720, yep.
Page 3720. This is another case involving a child. The stepfather's violation of her personal integrity. He'd attempted secretly to film her naked in their bathroom when she was 14 years old. And the relevant passage is on page 3740. Paragraph 80, regarding the protection of the physical and psychological integrity of an individual from other persons, the court has previously held that the authority's positive obligations, in some cases under Articles 2 or 3, in other instances under Article 8 taken alone, or in combination with Article 3, may include a duty to maintain and apply in practice an adequate legal framework affording protection against acts of violence by private individuals. So, and there's a footnote reference to, in particular, Osman and some other cases. So may include. 81. In respect of children who are particularly vulnerable, the measures applied by the state to protect them against acts of violence falling within the scope of Article 3 should be effective and include reasonable steps. And then at 82, there's a reference to international requirements, and 83, concerning such serious acts, the state's positive obligations to safeguard the individual's physical integrity may also extend to questions relating to the effectiveness of the criminal investigation and to the possibility to obtain reparation and redress, although there's no absolute right to obtain the prosecution or conviction of any particular person where there were no culpable failures in seeking to hold perpetrators of criminal offences accountable. So again, I say the Grand Chamber, when it's looked at this, has been careful to recognise that there may be this general investigative duty to ensure an efficient investigation, but the court has held, the Grand Chamber has held back and not stated it in general terms. It has focused on the position relating to children. One further authority before the court may think it convenient to break for the evening, and it's Sazula against the United Kingdom, which is volume 5, behind tab number 34.
Thank you. Yep. 1418. Yep.
And this is a 2006 decision. It's actually an admissibility decision. The facts are that in September 1964, the applicant was sent to a residential approved school by a court for having committed an offence. He remained there. The school was associated with an order of religious brothers. Throughout his time at the school, the applicant was physically and sexually abused by a teacher at the school. And then further down, 3 men were convicted on various charges, including the administration of electric shocks to the applicant. They were sentenced to 2 years imprisonment. The prosecution of a 4th suspect was withdrawn.
Yep.
And DS was not prosecuted, as the court sees from the penultimate paragraph. And at page 1420, at the top of the page under complaints, the applicant complains under Article 3 that there's been a failure in the state's positive obligation to ensure the enforcement of the criminal law and provide protection against sexual and physical assaults perpetrated on him. He complained there was no prosecution of DS as there were delays, failures to proceed without good reason, leading to the situation where the Lord Advocate can no longer prosecute without breaching Article 6 rights. And then at the bottom of the page, in a number of cases, Article 3 has been held to give rise to a positive obligation to conduct an official investigation, see Azanoff. Such a positive obligation cannot be considered in principle to be limited solely to cases of ill treatment by state agents, see Calvelli. Then over the page, second paragraph, on that basis the court found in MC, and your ladyship have seen that case, in the present case it's not disputed that the criminal law prohibited the physical and sexual abuse alleged by the applicant. There's nothing to suggest that the authorities failed to take seriously the allegations made by him and other erstwhile pupils. Investigation by the police began following receipt of allegations, and 4 prosecutions were brought, resulting in convictions. The court finds no indication that the authorities showed any lack of diligence or expedition, such that they effectively presented any possibility of a prosecution. And then a few lines further down, about 8 lines further down, while the sequence of events was somewhat unfortunate, the court does not consider that it discloses any culpable disregard, discernible bad faith, or lack of ill will on the part of the police or prosecuting authorities as regards properly holding perpetrators of serious criminal offences accountable pursuant to domestic law, etc., etc. At the end of that page, the court concludes no appearance of any failure by the state to comply with the positive obligation effectively and practically to prohibit the impugned conduct in this case. And that's the test, essentially, that we are arguing for. If there is an investigative duty, as a general principle, then provided that the state has adequate laws, then the investigative duty will only be breached if there is something tantamount to bad faith or a lack of will on the part of the police or prosecuting authorities to investigate.
What about culpable disregard?
Or culpable disregard, in my submission, means more.
Means bad faith, does it? Yes, I see.
It means more than they made serious errors in the way they carried out the investigation. What it means, in essence, is either they were acting in bad faith or there wasn't, in truth, an investigation.
It can't mean bad faith, because bad faith is specifically referred to in the next phrase.
But culpable disregard means that the state, the police officers, have simply failed to carry out the law that is applicable in the circumstances of the case. A very high test.
But this one wouldn't even meet the test of failing to do what's reasonably to be expected, would it?
No, it wouldn't. No, absolutely.
What about further down? Nor is there any indication of any systematic defect or shortcoming
In the applicable criminal law.
In the law, yes.
Yeah, that's the point. Right. And we say that is an indication of a test that is much stricter than in some of the other cases. But I repeat, I'm not suggesting that the law here, these cases, are consistent and coherent. My point is that they aren't, and that there are strong indications that the European Court has simply not grappled with the issues that arise in a case of this sort. There are strands of reasoning that strongly support our position. My lords, my lady, I'm sorry I've trespassed into after 4 o'clock.
I will resume
I've got a bit more, but I will talk to Mr. Eady as to how much time.
I expect he'll talk to you too.
He'll talk to me, yeah. No, we're allies here, and we're very happy to deal with matters in that way.
Very well. Thank you very much. We'll resume again at 10:30.
Thank you very much.
Court's adjourned.
Thank you.